Okay, so Robert B. Jacobs has been practicing real estate and business law since 1987. He has litigated all kinds of real estate disputes, including contract disputes, problem sales, construction defects, and title issues. He has represented both buyers and sellers of real estate, as well as general contractors, subcontractors, real estate brokers, agents, and a title company. Who are you? Why are you on stage? And today he is going to share with us Asset Protection 101, storming the castle, repelling the invaders, protecting your assets. Help me welcome Bob Jacobs.
Thanks, Jennifer. Great to be with you. Most of what I have to say today is on PowerPoint, so I'll move through it pretty quickly. And basically, I spent a lot of time working to put together assets most of our lives, and the question is, what do we need to do to protect that? So this first slide, where's the need for asset protection? Accidents happen, you can have a fire, business losses, driving. Here's an example, case in point. This is a case that took place in Nashville, Tennessee. Somebody put their kisses in the microwave to melt them, and that's what happened. That's fire with heavy losses, so pay attention to the Hershey Kisses when they're in the microwave. Dave says keep your kisses in the microwave, okay. Oh, I have a microwave, okay. TV dinner. Microwave, they're left alone to heat up. Yeah, they definitely got heated up. $120,000 house fire. Grinder. This was a grinding machine that was being used to repair a water pipe. And there were some sparks from the grinder in kind of a dry area. And you read, that's not a typo. There's the fire. Second largest fire in California history at the time that it occurred. The day that it happened, July 4th, 2007. You're interested in fireworks, not in fire, so yeah. Cedar fire. Seemed like a good idea at the time. That's the photograph. 14 separate fires, 2,000 homes. So they can get out of control. This is one of my personal favorites. Finish the job with a lighter. There you go. So the wind carried the burning paper out of the tree to some dry grass. The wind blew it to the backyard, then to a barbecue propane tank, and then this is what you get. If you look at the photograph, you can see that the roof is completely gone. It's just a loose wall standing up there in front. Not what they were expecting. Again, seemed like a good idea at the time. So, these particular fires were fairly self-contained except for the really big ones. But it's a remarkable point, if you take a minute and think about it, that a man or a woman in a black robe, seated on a raised chair in a government building, authorized as a judge, can speak the words or sign the paper, and they can take everything that you've spent your entire life to accumulate. Absolutely authorized by law in the right circumstance. So it's a sobering point. And of course the answer to this is yeah. You live a lot, can be days' wages or a lifetime. There are exemptions. So the law says that if you have, it's going to give you kind of a grub stake for your future life. They can't take your, your gold tooth or whatever. I mean, there are exemptions, but they're small and they're limited. So SAD, acronym for surprised, angry, or disappointed. It's a common theme in litigation. And if you think about it, it makes perfect sense. A lot of times when people file a lawsuit, when they call someone like me, they call a lawyer, it's because they're surprised, they're angry, they're disappointed. One of those three. That's a very big theme in litigation. How do you avoid that, someone becoming sad? Obviously, don't let them be surprised, full disclosure. Honesty is the best policy. Years ago, I heard a great comment from a very seasoned attorney when I was first starting practice. I've never forgotten. And here's what he said. He said, people look most closely at documents the second time around. Yeah. First time, let's get the deal done. Second time, what do these things actually say? And that means there's a problem. People know what to expect if you have full disclosure. And if you have full disclosure, honestly, if you've got something it can be tempting. If you've got a blemish on your transaction, if you've got something, there could be a temptation to say, maybe this will be an issue, maybe not, we'll just wait at that and let it go. The great thing about it is, and you know how this runs, when people are in the transaction, there's a climax, there's expectation, there's some energy going, some emotion, sometimes they're ready to go, and they don't really always get hung up on stuff that's in the papers. So much better to put it out in the papers, deal with it on the front end if it's something they have concern about, make an adjustment to price, get it fixed, address it, whatever, so they're not surprised on the back end. So much litigation could be avoided if that approach were used more frequently. If you're unsure whether or not something needs to be disclosed, here's a couple of tests, just super handy kind of rule of thumb tests. Number one, use yourself as a test case. If this were being done to me, if I discovered this on the back end, how would I feel? That's a great, easily used, very inexpensive test. Second test, New York Times test. What if this aspect of the transaction were put right on the front page of the New York Times? How would I feel about that? That's another great test. Two really easy tests. Pay attention, use care. Again, accident or injury. This is kind of the bottom point, is kind of the general California standard. When you talk about causing loss or injury to other people, the standard is, did they use reasonable care under the circumstances? We live in the computer age, and you think, it should be a 1, it should be a 0, there should be a bright line test. Sometimes there is, but generally it's reasonable care under the circumstances. And so what that means is if there's a dispute later on, people will be looking backwards, saying, what did you do? What should you have done? Was it reasonable under the circumstances? That is the single most common, largest test for liability. Reasonable care under the circumstances. So what if, despite our best efforts, they become sad and there's a problem? Well, there are some protective measures that can be taken. Insurance is the first one. It's the best way to deal with potential issues. If I stopped and added up all the money I paid in insurance all of my life, I'd almost choke. It's been so much. But I've always, it's just me. I'm very conservative. I've always been really well insured, and I sleep well at night. So it's tough. It's tough to part with the cash up front, but it's what insurance is all about. Corporate entity is another great way. Exemption planning. Exemption planning has to do with if people are trying to collect from you, either in bankruptcy or enforcement judgment. You can do some exemption planning up front. It can be very effective, very helpful. So some insurance considerations. I won't spend a lot of time talking about insurance. That's obviously the first line. If people get overly whatever, it may not be helpful in a criminal case. Sometimes it might have some application, sometimes not. Primarily designed for civil claims. What does insurance do? It defends and indemnifies you. So defense means that they pay the attorney's fees. Indemnity means if there's a judgment against you, the insurer pays the judgment. There's other protections besides, and we can talk a lot about insurance. So, here's an interesting for instance that nobody ever thinks about really. How about, because we've got liability insurance like a homeowner's policy or a premises liability policy or continuing operations coverage and all that kind of stuff. Title insurance, this is just a little tidbit. So what happens if your client buys a house in their individual name, when they purchase the property, they get a policy of title insurance that is written to them individually. And then they go see their estate planning attorney and they put this into a revocable living trust. Well, trusts are a separate legal entity. So what happens to the title insurance policy? Is there coverage or is there not? Vicki says no. How many say yes? And how many say no? You know what the lawyers say? It depends. It's always the answer, it depends. Some cases yes, some cases no. There was just a recent case that had to do with this, and the court system made some, it depends on when the policy was written and the type of policy it is, whether it's CLTA or ALTA. So it depends. So the best answer is their estate planning attorney should be up on this, have the master estate plan attorney, how does this affect your title insurance? And normally you can get an endorsement for just a couple $100. You know, the title insurance company really shouldn't care. You're not changing the data coverage. Just get an endorsement, goes over to the revocable living trust. But it is like so many other things that you have to do to protect yourself. It has to be done on the front end. I was recently at a seminar where this question was posed to a room full about this size of attorneys, and there was somebody who put their hand up and said, yeah, had this problem, conveyed the property to a revocable living trust, did not get the endorsement, had a title problem, tendered to the title company, denial of coverage. So it hopefully doesn't happen often, just something to be aware of. So other protections that can be available. Corporations, I have a question here. Speak loud.
Yeah, I just want to ask, if you take the title as Joe and Mary Jones, and then you have the Joe and Mary Jones irrevocable trust.
Jeannie, hold on. Nobody can hear you.
That surprises me. If you take title as Joe and Mary Jones, and then you transfer title to the Joe and Mary Jones Trust, and you're Joe and Mary Jones trustee, nothing's changed. It's the same people that own the property regardless of the title. I think if you push the title company, likely there'd be coverage. Because it's...
That's not what the court says. That's not what the court says. So, intuitively, yes. For tax purposes, same thing. For as far as ownership of the property and liability and exposure to liability, same thing. Title insurance, not so. There is a distinction on title insurance, and it depends. So you have to look at it very carefully. See me after, and we'll talk more about it if you want. Yeah, but it's not necessarily going to. The coverage is not necessarily going to follow the conveyance. Yeah, you have to be aware of that. Other protections: corporations, limited partnerships, limited liability companies. Really, a corporation sounds more stable and sounds more protective, but what's really the purpose of a corporation? Well, there's a couple of nice things. Corporations been around for a long time, long time. There's a very well-established pattern for control. So it's almost like a mini community, a corporation. You've got a president, you've got a secretary, you've got a board, you've got officers, people who run the corporation. So you have this asset or this entity that's got this organization, and so you have control and ownership. It's all very well clearly laid out. So that's one benefit to a corporation, is you've got this instantaneous structure, this body of law as to how we're going to operate this thing. The other real big benefit to a corporation is you have the corporate shield. And you get that same shield with a limited liability company. And so what society says is that we promote investment by limiting personal liability. So what that means is if you didn't have corporation shield available or a limited liability company, the concept is that people would be hesitant to do business and to put all the personal assets on the line. So actually, when you have a corporation, that's a statement by the law that says we are putting this up as a picket fence to hold off your creditors. We would rather see your creditors go unpaid than see you not do business because of fear of liability. So it's a built-in asset protection device. The assets of the entity are fully exposed. So whatever values in your corporation or your limited liability company is all at risk to creditors. But if you handle things right, then your personal assets should not be exposed. And so the if you handle things right is kind of a big deal. It's how the corporation is set up. It's how it is handled. Has it been maintained after it's been set up? You can't be commingling funds and claim that it's a separate entity. The test for corporations is if it walks like a duck. That was not me. If it walks like a duck, if it talks like a duck, if it quacks like a duck, most of the time it'll be a duck. But you have to operate like a corporation. One of the hallmarks, absolute hallmarks for disregarding the corporate shield is illustrated in a case I still remember from law school, which is starting to sound like a long time ago now. Somebody had 2 taxi cabs in a corporation. That was it. All the corporate assets was 2 taxi cabs in New York City, no insurance. No insurance. So, of course, what happens? Big, really bad accident, lawsuit, trying to pierce the corporate shield to get to all the other taxi cabs and the whole value of the company. The corporation says, no, corporate shield, we've done everything by the book, we've dotted our I's, we've crossed our T's, we're a corporation, have at it, 2 taxi cabs. The court says not so fast, partner. You know, set up in bad faith. You had no insurance, reasonably foreseeable that a taxi cab in New York City just might get into an accident. No, they pierce the corporate shield. That's probably number one. Fraud or inequitable conduct will pierce the corporate shield much of the time. After that, you have the corporate formalities about, you know, have you kept the assets separate, and have you held your meetings every year, and have you kept minutes and all those kinds of things. So those are important too. So it's a separate legal entity. We all kind of know that intuitively. Again, sort of the obvious things when you need insurance or a corporate entity. Contractual liability, if you can get people to just accept your corporation as the signatory, fine. Sometimes, you know, you're going to have to do a personal guarantee. You can't sort of get around that. Accidents, of course, are a concern. You have to go through the cost versus benefit analysis. The insurance, you have premiums. Corporate entity, you have all the paperwork and yearly franchise tax. So there's a cost to it. There's other asset protection strategies as well. Exemption planning. And just an aside, sometimes, well, I'll come back then, irrevocable trusts. People ask me that sometimes. So exemption planning, that means if you're going to end up in bankruptcy, you can do some planning that is legally allowable, but it has to be done in advance so you can soften the landing a little bit. Retirement accounts, IRAs, 401ks, most of the time, with limited exceptions, those are going to be exempt. So if you're going from a liability purpose, would I rather put an asset in just a stock account, or if I have an opportunity to put a 401k, you can have a lot of money in a 401k. It's like up to $1 million. It'd be exempt in bankruptcy. Unbelievable, but that's the way the law is written. So, yeah, very valuable for that aspect of it. Exemption planning, just what I talked about here. The homestead exemption is also exempt in bankruptcy, or can be. That can be up to $75,000 for an individual, $125,000 for a married couple, $175,000 if either spouse is disabled or over 65. So that homestead exemption can be a lot. What's difficult is sometimes people are getting into trouble and they come and they say, I liquidated my 401k, you know, I sold my house, everything that would have been exempt, you know, they can't staunch the flow or stop the bleeding, so it's very difficult. Irrevocable trusts. A revocable trust, you can revoke at any time, take the asset back in your name. Irrevocable, much more stringent, much more difficult. Asset can't, because you're not going to necessarily be the beneficiary in an irrevocable trust. If you put money in an irrevocable trust and you're not staring at a potential claim or claimant, which is a big if, then it may be protected from the claims of creditors. There's some legal principles that say, you know, if you're staring at a claim or a claimant, you know something's going to come. Can you start at that point trying to bleed your assets away? You're not the first person to think of that. That's been thought of before. There's some specific laws that deal with that. So if you've been sued with a lawsuit, you say, you know, I think I'll give Uncle Harry, you know, my motorhome or my ski boat or whatever, you know, that's a problem. So if you have people you want to give things to, do it before there's a problem. Once there's a problem, it's a bad idea. They're called fraudulent conveyances. Sale's not prohibited. In other words, if you've got a lawsuit you've been served with, you maybe have a judgment, yeah, you can go out, you can sell your boat for $30,000 if that's fair market value. Sell it to a friend, family member, take the cash. It's when you start doing it below market value that it becomes difficult. Here's some other considerations, and this is once you're into it, you know. I've seen these. The attorney sophistication makes a big difference. A lot of times it's possible to think, you know, well, I've got someone, they're a licensed attorney, it's basically like buying a box of cereal, you know, I mean, one's like the next one. Not so. An attorney is like an artist, and it's like a craftsman. We all know the craftsmen have different standards and different product at the end. No different with an attorney. The attorney oftentimes, unless it's something very simple, if there's any complexity, they're going to shape that problem and shape that conclusion, and the results you get many times will be based directly on the skills of the attorney. So it truly does make a difference on who you decide to hook up with. So in other words, if you have low attorney sophistication, they may not be set up to pursue kinds of claims, but you don't know that until after there's a problem. You can set up a Nevada corporation. A lot of attorneys don't know what to do with that. They just throw up their hands and say it's not worth chasing, and then you're done. An unsophisticated attorney may discourage a small or medium claim. Again, it depends on the attorney. So choosing a lawyer. The difference between a good lawyer and the right lawyer is profound. That is true. Anyone who's practiced for any degree of time will tell you that. So you think about it for a minute, what a lawyer is. A lawyer is a warrior. They wear a lot of hats. An analyst, a strategist, an advocate, a risk manager, definitely a negotiator, counselor, and basically a river guide. You need to be out there looking at which direction you're going to be going, what's coming up next, and how you can be prepared for it. Truly, it can be just critical, and you see this time and time and time again.
Very similar to a real estate agent.
There you go, the comment was very similar to a real estate agent. It's not easy to find the perfect blend. So, I didn't mention this at the beginning, I do a monthly newsletter. If you want to be put on the email list, just give me a business card with your name on it, it's a newsletter, and I'll put you on my list, and it's been great to be with you today.
All right, thank you, Bob. Did we find value in today's guest speaker? Everybody? Great. As you know, I always like to make sure you see value. I always make sure that I want to have a takeaway myself. So, and I like to share my takeaway. So, my takeaway with Bob is, first of all, does anybody here have a speedboat, mansion, vacation home, anything like that? Anybody? Perfect. And when you get in trouble, will you call me? Before you get in trouble, call me. I'll take the speedboat, whatever you got. All right? Thanks again, Bob. Thank you. Let's give Bob a round of applause. All right, Wendy, if you have any community